Mr. Chair, you are live.
Thank you very much. Thank you all for your patience. Let me open the meeting of the City of Annapolis Board of Appeals special delayed virtual meeting for August 19th, 2020. The meeting is being broadcast on the City of Annapolis YouTube channel. My name is Bob Gallagher and I chair the Board of Appeals. In accordance with the city policy during the pandemic emergency, the virtual meeting allows the public to observe the meeting through video link. Public also has the opportunity to submit written testimony through an online submittal process available on the city's website. Links to the YouTube channel and the website link for making comments should be available on the agenda for tonight's meeting. So we'll start with the roll call, and I'll ask our recording secretary, Tammy Hook, to call the roll.
Mr. Gallagher?
Yes.
Mr. Zazali?
Here.
Dr. Chen?
Present.
Mr. Walsh?
Present.
Mr. Dews?
Present.
Mr. Burnett?
All right, we have a quorum, so we'll charge ahead. Before we take up the agenda, a few notes on the virtual format. The people that you see on the screen are members of the Board of Appeals. When the case is called, the applicant's representatives and representatives of the city responsible for the case will also appear on the screen. Also participating in the meeting by audio only are counsel to the Board of Appeals, Cheryl Woods, our recording secretary, Tammy Hook, one or more of our technical wizards at the City of Annapolis who will manage the technical aspects of the broadcast. Also participating by audio may be other representatives of the city, including Joelle Braithwaite, city attorney and counsel of the Department of Planning and Zoning, and one or more members of the planning staff. We ask everyone but the members of the board to mute themselves except when they're speaking. If you wish to speak during the meeting, please raise your hand and unmute yourself and I will call on you to speak. As I mentioned earlier, written public testimony is accepted on the online format up until noon of the day of the hearing. So anything submitted up today by noon today would have been received by the board and made part of the record. Public testimony entered in the record will be available for public review on the city's eTrackit platform, also accessible from the city's website. Have the members of the board had a chance to look at the agenda, and are there any suggestions or corrections?
I have.
Okay, any objections or problems with the agenda?
No. No, I move the agenda be approved.
All right. All in favor?
Aye.
All right, the agenda is approved. The first meeting item on the agenda is approval of our minutes from August 4th, diligently prepared by Tammy. I've looked at them and they look fine to me. Do we have any corrections?
Some site for Zoom. There's nothing happens when I hit join. I'm not going to enter a new meeting because that's creating it. Chat meetings. I'm going to go to meetings. My personal ID.
Hello?
Who are we listening to?
Sounds like Heidi Halleck.
Well, Heidi, you have not been invited into the meeting yet. You will be when your turn comes.
Sorry, Bob. That's me. I'm actually working with Heidi right now. That was me. Sorry.
So I move the approval of the minutes.
I second.
All in favor?
Aye.
Aye. Right. The next item on the agenda is resumption of the public hearing in special exception 2020-003. And I think we have the representative of the applicants present. The purpose of the continued hearing is so that the board may consider any public comments that have been received as a result of in response to evidence offered at the hearing last time. Jackie, have there been any comments?
We have received no public comments since the public hearing on August 4th.
Right, and unless there's an objection, then I will close the record and we'll begin deliberations. We good with that?
Yes.
Okay, Christian, would you like to exercise your prerogative as senior member to lead off the deliberations?
I will offer my thoughts, such that they are that the application, I do have an interest in as much as that the property is very near to my property. It's adjacent to Admiral Heights. It's 1/8 of a mile from where I live. The intersection of Rowell Boulevard and Farragut is one of constant struggle, as are many intersections in the city. But I do understanding how they're going to address drop off and delivery and the hours that they're using, I don't think it's going to contribute. I honestly don't think it's going to contribute to the problem. You can contribute to a problem or retract from the benefit of the light any way you want to find it. I do know the basement. I've been in the basement. I've been there for choral practice and other meetings. So I know the facility is, and as is represented in the testimony and the evidence and the drawings, adequate for the use that they intend to use it for, and see no reason why the application for the special exception shouldn't be approved. But I will withhold my motion until others have a chance to weigh in.
Michael?
Mr. Chairman, I would concur with Christian that I find that the use being proposed is consistent with previous use that was there, as it was used for not only Sunday school, but also that it had been used, I believe, for a pre-K and other school-related facilities. So I don't have any concerns and think that it does comply with the conditions of a special exception.
Nadine?
I have no additional comments.
Rob?
I have any additional comments either.
All right, with that, I motion to approve the special exception SE 2020-03 for all the reasons stated in the staff report, finding it in compliance with all necessary regulation and testimony presented by the applicant.
Do I have a second?
A second.
Are we, just for my clarification, are the requirements of the staff report, the conditions in the
Yep.
staff report?
There are conditions within the staff report and they were accepted by as okay during the hearing.
Okay, then second.
All in favor?
Aye.
Aye.
All right, congratulations,
Thank you.
Ron. You've got your special exception. Thank you very much.
I appreciate it very much.
Bob, I was just on behalf of the applicant. I'm hoping that we can expedite preparation of the opinion and have it maybe adopted but in an email format to facilitate them being able to move into the new facility expeditiously.
I'm sure we'll be able to accommodate.
Thank you all. Thank you very much.
Thank you, Ron. All right, Julian, if you'd like to bring in the parties for Appeal 2020-002.
Yeah. I'm actually trying to pull the agenda up right now, Bob. Who is on that?
That would be Steve and Heidi and Mr. Henney.
All right, so Steve is here. Steve, you want to click that? Oh, Steve actually looks like he might be frozen. I know Heidi is trying to get on right now. She's having troubles as well.
Is Alan Hyatt still?
Getting off.
All right, Steve. Okay, there you're. All right, and then Mr. Henney, you are muted as well. And ideally, Heidi will be joining in just a moment.
Julian, you also need to add Alan Hyatt.
Oh yes, thank you.
Of course, of course.
Alan Hyatt's coming forward right now.
It wouldn't be a Board of Appeals meeting without Mr. Hyatt.
You're so kind. Thank you.
At least he has the best looking office.
Okay, yeah, I mean, everyone's here. I'm just waiting on Heidi to try and join in. Like I said, I know she's having some issues getting in tonight. Hey, Heidi, is that you there?
That is her phone number.
So I think she's just muted on her end right now.
Cheryl, it's nice to see you. I don't think we've seen you in one of these meetings before.
Thank you. Thank you. It's nice to be seen.
I apologize. Give us one second. I think we're about there. Mr. Chair, I believe we have another participant. It doesn't make sense, but she should be here. Heidi, can you hear us?
Yes.
There you are. And now so Mr. Chair, Heidi Halleck is now with you.
Thank you. That's been a long process.
Bob, you're muted.
Didn't want you to hear the dog barking. Appeal 2020-002 relating to the certificate, appeal from the issuance of the certificate of adequacy of public facilities by the Director of Planning and Zoning for the project known as the Lofts at Eastport Landing. We've got motions to deal with, but a couple of other issues before we get to the motions. I'd like first to deal with the issue of representation here, and I'd like to start with a few questions for Ms. Halleck. Trying to find, there we go. All right, Ms. Halleck, so you're familiar with this appeal. You worked on, I believe, the proposed findings and conclusions in the earlier phase. Is that right?
I prepared a memorandum of points and authorities, not.
Yeah, right. Okay. And you did that at the request of Mr. Rogers and Mr. Henney?
No.
Mr. Rogers, that's it. You're muted.
At the time, I prepared it as a, I was not retained. I prepared it as a citizen providing assistance, as I had done throughout the case.
But they were parties to the case, and you prepared it for them to file.
Yes.
All right. I thought you did a good job. Thank you. And so were you involved in the preparation and filing of the application to appeal in this case? Not the notice of appeal itself, the City of Annapolis form that covered it. It identified you as agent.
Yes, and I was aware of that. That was a mistake, a typo, and I had followed up with an email to Sally Nash to advise that that was a typo, and that obviously, oh, I see what you're asking for. I think I had typed in Alan Hyatt by mistake.
But you were authorized by Henney and Rogers to be agent in that form.
That is my understanding.
Yeah. And you sent a cover letter to Planning and Zoning that said that you were representing Rogers and Henney.
My understanding is that I represent Mr. Henney, and that Mr. Rogers was joining on the appeal as another separate appellant. And that's been my understanding throughout.
I read your cover email, and I don't think that's what it said. So you're saying you never represented, you were never authorized to represent Rogers in this case?
Yes, that's correct. I had initially thought that we'd had some discussions, and that that was something that when the time came that I would enter my appearance on his behalf. And my understanding is that prior to the appeal, I had indicated initially to Mr. Hyatt that I would be intending to represent Mr. Rogers, but that officially I never entered my appearance on his behalf. I had represented in all the pleadings that I represent Mr. Haney. And similarly, at the Board of Appeals consideration on the prior appeal, as you may recall, I sat down and represented and asked to appear on behalf of Mr. Haney only. And that same representation is my understanding, that I'm continuing to represent Mr. Haney only.
All right. Thank you. Let me ask Mr. Rogers a question. So, Mr. Rogers, the notice of appeal, I want you to listen to my question. I want an answer to my question. I don't want to go off into the ether. The notice of appeal filed by Ms. Halleck that you signed and had your name on it, at the time that was filed, she was not authorized to represent you. Is that correct? Hold on, I can't hear you. You have to unmute yourself.
Good.
Yeah, Now, will you answer the question?
She thought she had this, I had to sign that document to show that I was joining the appeal. But my supplement for my pro se piece of the appeal says that I'm joining, I'm not being represented by her. That's what my appeal says.
Mr. Gallagher, my understanding is that they are co-appellants and that I represent one of the co-appellants and he is the other co-appellant. And as such, both co-appellants signed the notice of appeal and that he provided, as Mr. Rogers stated, he provided supplemental filing with regard to the co-appellant's notice. And I liken that to when we were in all of the hearings at the prior appeal, that both Mr. Rogers addressed the board and Mr. Haney addressed the board as co-appellants.
All right, Mr. Rogers, the order from which you appeal was entered on May 26th. Is that right?
Well, I don't.
Never mind. I'm sorry I asked that. Your notice of appeal is dated June 26th.
Yes, that's correct.
And the ordinance requires that appeals be filed within 30 days. The director's determination was filed on May 26th. As I count it, your pro se appeal was filed on the 31st day. Tell me why I'm wrong.
Well, because I thought the 28th was the decision date, 26th is a mitigation date.
No, all right, that's your
28th
explanation.
is the decision date.
Okay.
So I'm within the 30 days.
So we're striking your.
Mr. Gallagher, if I may address that legally. On all legal filings.
On whose
the
behalf
court,
are you addressing it?
I'm talking about the date of counting 30 days. On all legal findings, the first day that's counted is the next day after it's recorded by it's recorded by the court. And in this case, when it was published online, I'm certain, or the date that it's filed. In all legal, and this is a quasi judicial board that applies the same rules as the courts and any other judicial board. And when anybody counts, you count, the first day is counted is not the date of filing, but it's the next business day. And as such, the 26th would be within the 30 days. I have never found any other legal body that does not count it appropriately. And I'm sure, for example, the attorney for the board, Ms. Wood, would understand that that is legal counting.
It doesn't say that in the ordinance. Counsel, do you have any advice for the board?
It doesn't say anything otherwise.
It says 30 days.
Right, but
Ms.
when
Wood?
does 30 days commence? You count from the first business day afterwards. Mr. Braithwaite would also note that in all legal counting, that it's the date
All right,
30 days after.
I've heard enough.
I'm sorry. Yeah,
Ms.
it
Ms.
doesn't
Wood?
say, it doesn't, we don't have a similar rule on counting that they do for the circuit court, for the district court. And so it's 30 days. It's up to this body how they decide to function. And that's the way that they've been functioning when counting the 30 days. So they are permitted to do that.
Okay. So unless any of my colleagues on the board have a concern, my inclination is to dismiss Mr. Rogers' separate pro se appeal. Any concerns on that account? Okay. All right, Mr. Rogers, thank you very much. Now, Mr. Rogers. I've lost Mr. Rogers.
I'm still here.
All right, there you are. So we're dismissing your separate pro se appeal as untimely.
My separate comments, my supplemental comments, I'm still part of the appeal as an appellant.
The way I read the papers that are on file in this case, and notwithstanding Ms. Halleck's explanation, she filed on behalf of both of you. So you are on the original appeal. That's true. If you want to separately represent yourself, then you're going to have to explain to me in a motion to discharge counsel why you should do that.
I don't understand your statement.
Well, maybe Ms. Halleck will explain it to you. So you have choices here. You can withdraw entirely. You can proceed as a co-appellant with Mr. Henney, represented by Ms. Halleck, if she'll have you back. Or you can move the board to allow you to discharge Ms. Halleck as your counsel.
No, I'll work with Ms. Halleck.
Wonderful. That's very much appreciated. I'm sure you won't regret that decision. Terrific. All right, now we're going to get on to this motion to strike stuff. Let's see. No, before that, we're going to deal with these notice issues. So let me hear first from the city. I don't know if it's Mr. Braithwaite or Ms. Nash, but what is the city's position on whether the appellants have satisfied the notice and publication requirements?
Joel Braithwaite on behalf of the city. We know that our August 4th, we weren't able to move forward on August 4th because publication requirements were not met. There was conversation as to whom some blame or any blame falls on. But I note that in order to perfect an appeal, there's a notice of appeal, which is the beginning of the appeal. But then there's procedural steps that must be taken in order to perfect the appeal. Here, where the publication was not made and within the parameters of the city code to allow the hearing to move forward, I would argue that that requires dismissal, but the reason I'll argue it requires dismissal because it's a violation of the city code. With respect to any rule that was violated, that's a rule of procedure for the Board of Appeals. I do believe that those are procedural rules that can be waived at the chair's election or at the board's election. But with respect to the city code, I do think that the city code must be complied with strictly in order to perfect the appeal, and the failure of timely publication would be a defect in the perfection, and therefore the violation of city code can be excused by the city council, but cannot be excused by this board. So I believe that it operates as a bar to this appeal being perfected and moving forward in a timely fashion.
And they haven't cured it as a result of the later publication and continued hearing date? I mean, haven't they accomplished the purpose of the rule by getting timely notice out to those who are intended to get it?
The defect and the cure, I think, are two separate issues. I think the cure goes to mitigation if that is allowed. If to the extent the board believes it's within their power, to the extent a city code provision was violated. If the board believes that it's within their power to excuse a violation of the city code or non-compliance with the city code, then I do believe that the board can listen to the facts and mitigation and come to its conclusion as to whether the cure matters. But I do know that the postponement was in large part due to the failure to publish, timely publish. And I believe that that is a failure to comply with the city code. And I'm not sure. I wouldn't argue that the board sits in the position to waive a city code requirement regarding the timely perfection of the notice.
Okay. And then let's talk about the publication issue. Ms. Halleck, Mr. Hyatt has raised the question about notice to tenants. Did you notify all of the tenants that you had knowledge of?
That I had knowledge of. I will, do you want to go back to the original issue or are we jumping to the second one?
We jumped to the second one.
Okay, thank you. I mean, I think I made it clear on the prior one what happened and how that happened and that we were on the second notice. Secondly, with regard to the tenant issue, first of all, I used the list that was provided, and I believe the city generated this list to provide notice. I understand that the law has changed with regard to the requirement with regard to tenants recently within the last year. I got in touch with Ross Arnett and discussed this with him about what do you do if there's no way for a party to ascertain who rents, who doesn't, what their legal mailing addresses are, and how they're just, we have an inability to comply with that. And Ross, he said that there isn't really a way to do that, and that's what they discussed. And I don't know that there's a way to do that. There is no way that a citizen appealing this case can comply with that because there is no way to know who rents, who doesn't, who legally rents, who doesn't legally rent, if they use a post office, if they don't have their mail delivered there, if they have a postal box, not using the residence. There's just, it's an impossibility to comply with it. And so I sent it to a city generated list that included all of the people in the code. We've got, as I responded, we got everybody, the Ross, the Civic Association, the people with financial interest, the people that, but with regard to the tenants, I'm at a loss on how it's impossible. How would you expect an appellant to be able to get that information, to provide that list, to mail it out? They're not even.
Okay, so you acknowledge a duty to notify the tenants. It's in the law. We can't avoid that. But you've notified all the ones you know of.
Is it required under this application and this process? Because at the time that this application was submitted, that was not the law. This is only a very recent law, and I'm not certain when it came into effect and whether it is applicable.
It was in effect at the time the appeal was filed.
Okay.
So, Mr. Hyatt, let's hear from you.
Yep, thank you. I would acknowledge that it is a difficult law to satisfy. And it's not just for appellants, it's for anybody who's made an application that results in a public hearing before the Planning Commission or the Board of Appeals. And I can tell you that it takes a lot of effort. And we at one time did obtain a list of the tenants the best we could within 200 feet of this property. And that includes a fair number of apartments at Watergate Village Apartments. And you know how you do it? You go to the buildings and you see, okay, there's unit A1, unit A2, unit A3, and you send letters to tenant unit A1 at Watergate Apartments, Annapolis, Maryland, 21403. And you do that and you make an effort to comply. And there's tenants within the shopping center that are pretty obvious. They should have gotten notice. And you send notices to the various addresses. If you're unsure if there's a tenant in there, you send it to tenant or occupant. And that's how we adhere and comply. But there's more to it than that. There's also a requirement to send notice to the president of any community association, homeowners association, condominium association. They keep a list in the mayor's office. That's what the code says. And under 21, and all parties with a financial or vested interest in the property are supposed to get notice. And what the appellants did here is submitted affidavits that said, we notified everybody in accordance with 2110.020, which they didn't, but they said they did in the affidavit. And then they attached the property owners within 200 feet. So they failed to adhere to this. And this is a must comply with. The code says that notice must be given as follows: all parties, property owners, tenants, older person, president of homeowners associations, and so on and so forth, as I mentioned. And they did not do it. They botched this up twice. You know, we had the one case that was postponed from August 4th. They did not do it then, and they did not do it now. And I think for that reason, you should dismiss the appeal. It just wasn't done right. And I don't disagree that it's difficult, but you go through the exercise and you give the notice, and that just plain and simple was ignored. And what's the consequence here? If they don't follow the code and the rules, kick it down the road another month? It's not right. The rules, the integrity of this organization or this body relies upon adherence to the code and the rules. And these appellants, plain and simple, don't do it. Didn't do it once and didn't do it the second time.
I'd like to address that.
All right, Ms. Halleck.
Number one, the consequence that you note in the code, if a business owner or an applicant fails to publish, then the proceedings are stayed and they're reset, and the notifications are then posted again. No, it says in there that in the code, in the city code, that the relief of dismissing it is a hardship and inappropriate. Same applies in this case. That first of all, the notice provisions, and this is supposed to be a quasi judicial body, and this is not the Court of Appeals, that every single absolute nicety of the law is to be required. The difficulty that you're presenting, that is presented here, makes it an impossibility for all appellants to achieve the level of notice that for example, if Mr. Hyatt is asking for absolute strict compliance, then by just merely mailing it to Unit 1, Unit 2, and Unit 3 doesn't work. If they don't receive their mail and it goes to a post box, then you can't deliver it, and so they don't have notice. In other words, there's an impossibility built into this code that I can't, or anybody applying. I do not believe the legislature intended that if we can't comply with all of this, then we can't do this. Now, for example, this is the first we've heard of this issue. It didn't happen prior. It didn't happen ever. The notion of tenants to have to go around to every single Watergate apartment where it's a locked and gated community in many places, or they're not home. How do I know what are the apartments? How do I know who lives there? How do I know it's not the owners? This is absurd. And I get Mr. Hyatt's position is that, well, if you didn't comply with you didn't do every single thing, it must be dismissed. The remedy does not match what's happening here. It shouldn't be dismissed. We're not at the merits hearing. We can provide that. I'm going to tell you that if this is a new law, and this is the first time the board is hearing it, similarly, the board is going to have to craft a way to apply this law that works fairly for the citizens and for the residents of Eastport and all of Annapolis. And for the requirement to say that we're not the builders. We don't have the resources. We are residents. And for the board to say now that we have to go and we have to send out a legion of workers that we don't have to try and ascertain who the tenants are in all of the buildings, sure, we could try. For the next merits, I'm going to propose a remedy here, a relief. For the merits hearing, which is where this is actually going to be discussed, I propose if the board requires it, I can send notices to just the random residents, hoping that they have mailboxes, and maybe that satisfies what the legislature intended. But for me to camp out in front of the Watergate and
All right.
try and find how many units there are,
You've made your point. The board's gonna take this one under advisement for a while. We'll let you know.
Could I make a statement?
What is it, Mr. Rogers?
Well, I've had 2 tenants in that area move since the appeal was made. So the new tenants don't even know what's going on if they were sent the.
Yeah,
notice.
you're not helping your case. You want to rely on Ms. Halleck for this. Thank you very much. All right.
thank you.
Board's going to take that under advisement. And let's talk about the motion to strike. Okay. Ms. Halleck, you're aware that there's a stay, an automatic stay on the project during the appeal, right? So to me, the implication of that is what you really want to get out of this motion is to get rid of the case before we even have a hearing, sort of a summary judgment.
No, actually.
Well, wouldn't that be the result of what you asked for?
No, my point is that there needed to be, my understanding on this statute was the requirement that there be a 6-month period before they can resubmit. And that could be then considered to be resubmitting. And the date is September 6th or whatever it is coming up.
Was that your only ground? Was the 60
Sorry, 6 months, excuse me.
Was the 6 months, that was your only ground for the motion?
Yes. And that was to say that the adequacy of the APF requirements were deemed inadequate, and that as such, the 6-month period had not lapsed before they resubmitted it and the board reconsidered it. Now, I will tell you, like you, I've read this code. I've read the code now backwards and forwards about 6 times, and I will concede on this issue. At first reading, it appeared to me that, not at first reading, first few times through it, it appears to me that the purpose of that is if you're deemed inadequate, there's a 6-month period before it can be resubmitted or reconsidered. And what I listened carefully to the positions of Mr. Hyatt, and I reread it carefully, and I see that there had to be, that this board crafted something in between. They didn't certify the adequacy, and they did not deny the adequacy. There was no denial. So there's no written finding that says, other than the board, your opinion does say, we find it inadequate. But, and you did, you didn't just procedurally send it back and remand it on redoing the standards or writing adequate reports. You went further in this case to say that they were inadequate. And upon a finding of that, but you did not officially deny it. And I will concede on that, but I want to make sure, I'll come back, but I do understand the purpose of it was that the city attorney had represented at your second hearing on the reconsideration in March, that the process going forward would be that they would look at published standards, do that, and reconvene with the stakeholders and go through the remediation or the reconsideration process. And he said it very clearly in his presentation that they would contact the parties and the community stakeholders and reconvene on this issue. That never happened.
Right. It was not part of our order to change the process on how the planning department does that. If you've got a beef with counsel for the city, you can take it up with him. Do you have anything, Mr. Braithwaite, to add on the 60-day, 6-month issue? Other than what you've said in your papers?
No, given that council has conceded the point, which was the sole argument in the motion in the motion to strike. When I initially wrote my response, I was laboring under an assumption that the notice of appeal that they filed, they were going to be able to perfect that notice of appeal, and therefore have a separate independent basis to go forward. My motion asked that this be denied as moot. But to the extent that it is now potentially something that was timely filed by them, even if procedurally improper, I would ask that the board rule on the motion and having it had the motion and the various oppositions filed, and provide an opinion, because I note that this argument is actually argument number 1 in the notice of appeal. So I'm not sure if the board is ever going to get to that.
Yeah, good point.
Appeal. But I do note that this is an opportunity to deal with that. But I do also appreciate Ms. Halleck's concession on the point.
Yeah, thank you. All right, Mr. Hyatt, you were so persuasive here. Is there anything more you need to say?
Well, perhaps I should not say anything further. Was that persuasive? Is it accurate that Ms. Halleck is withdrawing the motion to strike at this point?
Well, no, she's not withdrawing it, but she's conceding the point, and the board is about to rule that the motion to strike, to the extent it relies on the 6-month rule, fails.
Well, fine. I agree. There is no denial, so there should be no 6-month rule, and the motion to strike is really redundant. It's an appeal, and there's no need to file any motion to strike.
Okay, but let's come back for a minute, and this even gets close to scheduling issues, and it's also related to the notice issues. We have in the record everything that went in during phase 1, I'll call it, which is probably enough to fill a storage locker. We've got the new notice of appeal and the application for the notice of appeal. Of course, the motion to strike is part of the record. We've got the decision of the director and the supporting underlying documents from the departments. I'm wondering what else in terms of documents or testimonial evidence we would be looking at in a hearing, or can we do this on briefs and argument? Ms. Halleck, I'll ask you first.
Initially, I had thought that maybe that is somewhere we could go. But in reread, I'm looking at Director Nash's full opinion, and she's come forward with what appear to be different standards that she feels that they've identified standards. I'm just going to leave it at that on the remand, that she feels prevents her from, let me do it another way here. There is a notion of res judicata in this case, and I do understand that the board has proceeded and determined that the adequacy of the 5 areas that weren't adequate. Then the remand occurred, and then the now turning around of the approval with some limited conditions. And I think the board needs to hear what these limited conditions are, how they got them, and how those comported or fixed the major failings that the board identified. it's helpful if I use an example. For example, the boards on 2 areas. The board said, I'd like to use the sidewalks because it's an easy thing to say. The board determined that on non-auto transportation, that the sidewalks could not support, were inadequate. And they're designed it, and they have them at 5 feet. And the board made that determination and sent it back for remand and reconsideration, for want of a better word. Well, it was approved without any increasing of the sidewalk to accommodate the multimodal use and whatnot that the board identified. So without changing it, except they did do one change, is they required a sidewalk on the other side of the street on the back end of the project. That's one example. Stormwater. The board said there is not a requirement to fix the stormwater here, and we find that inadequate. And that this project was then again certified on stormwater with only a $17,000 contribution on a step pool, which is not, there's not even anything in there that says just to use. In fact, it rolled it back. Or for example, on traffic, there was no reconsideration of the data, the concerns of the board. There was no reconsideration of that troublesome intersection. In fact, the left turn lane was removed because based on the position that we had. So that in each of these cases, there are a lot of details here that I'm talking to you about that were just not addressed or concerned, did not get any consideration, or there were no changes made. But for some reason, Director Nash and the director of each of the departments felt that they can ignore the board's determination with not really any kind of conditions and approve it. And I don't know how that happened. And I think the board needs to hear why, how.
So, all right, I understand your point. So your plan is to do that by cross-examining Dr. Nash?
Or the departments that determined that, how did they come up with their determination of adequacy in the face of, I would ask them each of those questions. I would probably play back what the board said on each of those sections to say, here's what the board determined. You can hear them. How did the board's concerns, how were they addressed by you and how were they resolved? And I think the board needs to hear that. Maybe not, we don't need a whole lot of experts, but I think it would be, we need them to come back in and explain, how is it that you approved it now? Or for example, in the police department, very important, there is a determination of inadequacy. And then there's a mitigation approval so that the adequacy is determined. We need to, you saw my brief and my notice to say, I don't believe that that adding a couple of rental security cops in the evening addresses the need for police officers and safety as required by the code. And I think the board needs to discuss and hear why for example, why is it inadequate that you can't just use a rent-a-cop in the evening to address police and security requirements in the code? And I use the examples of 15 things that police officers can do and that security officers can't do. And the board, I think, needs to talk to the police department to say, there's this argument that the mitigation is required, that it has to be a certain level. And does it meet this level? I think you need to hear those things.
I understand your point. All right, let me come back to Mr. Hyatt and scheduling. We have set aside September 2nd, which is our regular meeting date for this case. Now, we've got the issue of notice to deal with and whether it should be dismissed. I'm very reluctant to dismiss it. If we don't dismiss it and have to go through some kind of remedial notice procedure, then we're not going to be able to start on September 2nd, and I'm not sure when we will be able to start. So I guess what I'm wondering is whether, Mr. Hyatt, you would be willing to withdraw your objection on notice in order that we move ahead with this on September 2nd.
Mr. Chairman, I think if you're telling me you've made up your mind that you're not going to dismiss the case, then I guess you could make that ruling, but I think that you should dismiss the case.
I don't want to make the ruling. That's why I've asked you if you'd like to withdraw it.
No, I would not like to withdraw that because I think that we have strong grounds for dismissal. There's a failure to comply with notice requirements, and I've also, they didn't comply with publication or notice requirements on the first round in a timely fashion. So it's twice. What's that?
Too late for the first round.
Well, I understand that, but it's a pattern, and there's a reason that the code provides what it does, and if they don't have to adhere to it, then I don't understand why the law is in place. I mean, certainly we have to adhere to legal requirements, and I wouldn't expect anything different from the board if we didn't comply.
Well, the board will figure out the motion, but as I say, I'm reluctant to dismiss for that reason. But I also feel badly that this case has dragged on for so long. And I know you've been anxious to move it along, and I would love to do that. But if we've got to deal with the motion to dismiss and possibly remedial notice, I can't tell you that it's going to be as fast as I'd like it to be.
I understand. And am I able to respond to the prospective proceedings, assuming you don't dismiss? I mean, Ms. Halleck spoke to them.
Yeah, sure.
Okay. So the way I look at this, the question before the board is whether the Department of Planning and Zoning, in conjunction with all the other departments, acted in response to the remand. I mean, this board issued an opinion, an order, and remanded the case back to the director and the departments. And I think the argument should be limited to whether, in fact, the departments and the director adhered to your directive. And otherwise, we have the same parties, we have the same project. I mean, nothing has changed. There was not an appeal of your decision. And, it ought to be an argument on whether the 5 criteria were handled in the manner that the board directed. And that should be the case if we do proceed on the merits.
Yeah, the board had concerns about adequacy of those 5 items. And I think the board wants to understand what the city has done in response to those concerns. And I think that we will probably hear an explanation from the city on what they did. All right. Okay, so the motion to strike is denied. We will rule on the motion to dismiss after I have more of an opportunity to consult with counsel for the board. Ms. Halleck, I'll just advise you that we're not going to hear any evidence relating to any of the 4 other facilities. I know that was something that Mr. Rogers was looking forward to getting into. Mr. Rogers, is there something you have to say briefly?
So I just have a question for you. My question is, do you consider the vacation of the original approval to have set aside the original approval? And in accordance with the code, it says if one fails, they all fail. Do you consider the need to the planning and zoning director to reaffirm all 9 or just the 5?
Mr. Hyde, this is the kind of thing I'd suggest you talk to your counsel about, but we're only going to hear evidence on the 5 facilities that the board had concerns about.
Thank you.
Okay. Let's see. Is Jackie still on?
Yes, she is.
Jackie, can you unmute yourself? Earth to Jackie.
I'm here.
Okay. So I don't think we're going to be hearing this on September 2nd. What?
September 1st.
September 1st. And unless there's an objection from my colleagues on the board, I just want to tell you now that we won't be having a board session on November 3rd, Election Day. We're not going to compete with people's responsibility to vote. So given that, what can you tell us about the availability of the schedule for this case?
We have the 3rd Wednesday in September, which is September 16th is an available date.
That's my birthday.
Well, what a fitting way to spend your birthday.
For a reprehensible life.
Yes.
I'm sorry.
And the next meeting after September 16th would be October 6th, is the first Tuesday in October.
All right.
The 3rd Tuesday in October is October 21st.
You mean the 3rd Wednesday?
I mean the 3rd Wednesday, sorry. Yes, that's what I meant.
And you don't have any competing items for that schedule?
We have not set agendas for September and October. I do anticipate that we are going to have some things coming in, some minor, I know of at least one special exception application that will be submitted. And we have a variance that is going to have to be heard. It's one that you've heard before. It's 38 that needs to be reheard, and that's going to be scheduled. Needs to be scheduled in September, but I don't know that. And then wait. There are other things that will need to be scheduled this fall. There's the Public Works Garage on Hudson Street, which has to go to both Planning Commission and Board of Appeals, and I think there is one other project that somebody has that also has to come to Planning Commission. So we do have some projects that we will have to work into the schedule.
All right, so let's tentatively think about the first Tuesday in October and the 3rd Wednesday in October.
Does that mean that you don't want to meet on your birthday?
My dear, it's my 75th birthday, and if I don't have a nice dinner out with my wife somewhere, I'm going to be very disappointed.
Okay.
You won't see a 76th.
Exactly.
Okay, so we're looking at either October 6th or October 21st. And I think that, so those are the two October dates.
All right, so let's talk about the schedule. Assuming we start October 6th, I'd like appellants to provide us 3 weeks in advance of the names of their witnesses and a sentence or two about what they're going to talk about, a list of any documentary exhibits they expect to offer.
Can I just,
Yeah, sure.
thank you. If my input is this, having sat through the previous chapters of this saga, is I understand what Ms. Halleck says, and I'm very much aware of you know, her desire to want to get into those areas that were part of the new order. But I really would be reluctant to be a part of a long dog and pony show. And I say that because there were hours of testimony, well and late into the evening on most of those hearings, that by the time it got to a point where we could ask a question, it was just either out of sheer exhaustion or having lost the train of thought somewhere before.
Yeah.
I want to keep it, what I would suggest, and for your consideration and that of the board, is that we limit, if Ms. Nash needs to bring a department chair with them, that's great. But I really would be hesitant to open it up to much more than that.
Well,
it is, I would let Bob, we can set the rules here and now. It's within our power.
We can say, well, I can ask the questions. I know that Ms. Alex said, you know, she can play back what was said. There's questions I'd like to ask, and I know fully well what was said in those previous hearings.
Yeah. Yes, Christian, had you finished?
Yeah, I was going to go on a little bit about, so long as we apply the rules uniformly going forward, it's within our power to make the rules for the. But the city attorney council wants to say something.
Did you have something you wanted to offer, Cheryl?
Or Joel, sorry.
No, Joel, I'm sorry. Joel, go ahead.
Hello, good afternoon again. Joel Braitman on behalf of the city. My input is this. I think that if you do allow the appeal to move forward and you find that the city code in this instance as applied is a procedural rule or a claim rule that can be waived at your election, it's not a jurisdictional rule that must be complied with in order to give the board jurisdiction over the matter in the first instance, and you do decide to move forward with a hearing, I would ask for a strict limit on the time, the presentation of evidence. One of the things I would suggest as a sanction for the non-compliance, if you believe that the board can move forward over the non-compliance, would be something like a limit of time, maybe 1 hour's, maybe a 1 hour to 2 hour window to present any evidence that they believe bears on proving their point. And to the extent they accomplish it within the 2 hour time frame, then that's acceptable. And if they did not, they will, the onus will be on them to structure their presentation of evidence such that in a way that it is cogent, short, timely, and effective. And I believe that that's one sanction. If you believe that you have jurisdiction, that is one sanction that you can put in place. As for the city notes that we, on remand, we have attempted to put forth a format in writing to give the board in particular full breadth of everything, consideration that we had in making our determinations. With that in mind, it might be if the board reads our written submission, the determination, and has questions and wants to hear from specific persons within the city's employ, the city will provide that witness for you. If the board, in reading the the factual or the discussions that we have as to each adequate public facility on remand, if the board has no questions for someone, then it may not necessarily be necessary for us to bring that person forward because the board has no questions. The purpose of the writing was that we might be able to submit on the papers without the presentation of further evidence. But if the board believes more evidence is necessary, we'd be happy to provide those, that evidence. So again, I think that on remand, we're in a special procedural posture where it may not necessarily be that we need the presentation of evidence from all parties, but only the evidence that is likely to help the board come to a decision. So it's not that every witness anyone wants to put forth should be entertained, but only those people that are either going to bring dispositive facts or facts that can change the board's opinion.
Yep,
It is.
I understand. Mr. Hyatt, I'm sure you want to say something on this subject too, do you?
Well, I do. As I stated earlier, I think the case, if it goes forward on the merits, and I urge that it does not go forward on the merits, as you know, but if it does go forward on the merits, I think all of the documentary evidence before you should consist of the record that can be referred to and consulted in this next go round, and that the argument be limited to whether the city followed your directives. Namely,
you have a guilty look, Nadine. Go ahead.
So you know how this case can go far afield, as it did over the 15 months that you heard it. And I think you whittled it down to the 5 criteria. You directed the director of planning and zoning to reach out to the departments and, in conformance with the purposes clause, explain why it is that you think the criteria have been satisfied. And I think the review of this board ought to be whether they did what you directed them to do. And I don't think that's going to take many nights of hearings. I just, that ought to be fairly limited to the arguments between both sides. And I think it'd be not appropriate to bring in any new expert witnesses or any documentary evidence, because you have it all. I mean, you have everything.
Okay, here's what we're going to do. I'd like a week from today, a brief from Mr. Hyatt, Mr. Braithwaite, and Ms. Halleck on the appropriate remedy for failure of notice. Specifically, whether the board is required to dismiss or has discretion as to some other remedy. The problem, Mr. Hyatt and Mr. Braithwaite, with your view of limiting the hearing is that there's a bill that's still bouncing around the city council that would change the standard of review on appeal to one of review on the record. That implies that that's not what we have now, and the code says that's not what we have now. The code has a ridiculous provisions that say on appeal, the appellant has the burden of proof, and that it's a de novo determination. That's crazy. So we've done the best we could under those circumstances. I believe it's not a review on the record. But at the same time, we've heard a lot about this case. As you point out, the issues have been narrowed down greatly. So I'd like, as I said, 3 weeks before the start of the next hearing, the list of witnesses and exhibits and short statements about what the witnesses will be asked to testify about. Ms. Halleck, you, as far as witnesses from the government, I'll ask Mr. Braithwaite and Dr. Nash to make Dr. Nash available and to make one representative from each of the departments available if you think you need them. you work out with them and make sure that people are on the list when you file it 3 weeks.
Each of the 5 departments or all departments?
The 5 departments.
I understand that some, like Dr. Nash covers, well, I understand that.
Yeah.
I guess I'm just going to point out that the bottom line here on this case, and just to boil this down, is that the question at issue is what is adequacy on this, and whether or not, I think Director Nash made it clear to say when she said, I can't find the standards that require me to do this, to do anything more on these issues. And so that is her position, and that is the city's position. And
Wrong.
I think
We object.
Yeah, that's an argument you'll make at the hearing.
I get that, but just in terms of this position, in terms, what I'm saying is, I would request that I have an expert, a city planner from outside of the city that can testify to what other jurisdictions do and requirements with regard to adequate public facilities. And I think the board would find that helpful as to what is in their determination of what is adequate. In other words, is only the bare minimum required, or does the board does this planning and zoning require discretion for each project?
I'll give you one expert witness. I'm not going to set time limits for your witnesses now, but I won't hesitate to cut you off if I think you're repeating stuff or going into areas we don't need to address. But I am going to ask you to, we typically go 4 hours. I'm going to ask you to try to wrap up your case in 2.5, 3 at the most. And then we'll see what Mr. Hyatt and Mr. Braithwaite have to offer. I don't expect they'll have a lot. As before, they'll probably spend most of the time on cross-examination.
Mr. Chairman, could I get a clarification from you? You said you wanted briefs for the appropriate remedy on the failure of notice. When do you want them?
A week from today.
Okay.
So, Bob, just to be clear on the deadline, so today is August 19th, so that would mean the first brief, it was due next Wednesday, which is the 26th.
Right.
And then September 15th is 3 weeks prior to the October 6th meeting, so that would be the deadline for submittal of.
That sounds right.
And then are we re-advertising the hearing for October 6th, or is that?
No, we're going to put it in the record tonight.
Okay, just asking. So we're continuing the hearings to October 6th. We will repost the property as we've done before. We will update the posting.
Whatever your usual practice is.
I think that we did that with the last set of hearings. We updated the dates on the signs, but we did not re-advertise in the paper nor send new letters. Tom, please correct me if I'm wrong about that.
You're correct, Jackie.
Okay.
All right.
Mr. Chairman?
Yes.
I would just like to kind of weigh in here, just on same as Michael. The five departments that we voiced our opinion on, were really there to give guidance to the planning department and the applicant where we felt the whole process came up short. And in some cases, perhaps we did use the words that it did not meet. But it was more of the city's process that we had issue with, is why we remanded it back, not necessarily focusing on the failure to meet.
That's right.
Right. And of those 5, clearly some are more nuanced and more technical in their burden to meet the requirement than the others. So I think you're very generous in your 2.5 to 3 hours. I just do not think they need the fullness of that time. At least 2 of them should take 10 minutes. The other 3 might be a little more nuanced, but I trust your judgment and to be respectful of 16 to 18 people's times. Time, is it plural, time?
Yeah. I believe we're going to wrap this whole thing up in 2 nights.
Okay.
That's my intention. If
So
it was
two more nights or just 2 nights period?
2 nights, not including tonight.
De novo, 2 nights de novo.
Right.
So one more point of clarification, Bob, just so that we're all clear. So for the October 6th hearing, your expectation would be that representatives of the 5 departments that are the subject of this meeting would be all present for that?
Well, it's up to you and Ms. Halleck to negotiate whether she needs them and who they are.
Okay.
This is Joel Braithwaite on behalf of the city. The city bears no burden in this case. The city doesn't have a burden of proof, doesn't have a burden of production, doesn't have a burden of persuasion. With the lack of burden on the city, it should be for Ms. Halleck to put forth evidence, Ms. Halleck to put forth in her motion, and basically her evidence must support her motion and must be limited strictly to the terms that she appealed on. To the extent the city must put forth witnesses and we don't have a burden, I'm not sure how this works, how this plays. If Ms. Halleck would like to call as a witness one of our city employees relevant to the specific inquiry she wishes, we'll make that witness available. But it is not the city's position that we have a burden of proof or production or persuasion. And we have already provided our written evidence, and the city is going to, but for they put evidence into controversy, we don't intend to put forth responsive evidence to the extent they haven't raised the issue or put forth any evidence that we need to rebut. And that's currently our position, and we'd like advice from the board on what it believes the city burden, if any, is with respect to these hearings.
All right. Appellants do have the burden. It's clear from the law. Ms. Halleck quite properly plans to put on her case through the city's witnesses. She'll be examining them as hostile witnesses. She'll be cross-examining them to ask them how they got to the decisions that are the subject of the appeal.
And I'll object to her being able to cross-examine witnesses where I am, if I didn't have a direct examination, I'm not sure where a cross is. Yeah. And I'm not sure that any witness that the city proffers or puts forth on behalf would be adverse to a position. I believe that they should not be placed in a cross-examination mode until.
I won't use the word cross-examination. She has the right to call witnesses from the city, and she can question them as hostile witnesses because their interests are adverse to hers. And so that's the same as latitude you get as you're doing cross-examination. That's what I meant. So, and under the rules of the board, the board can sit down with the director and identify who from the city we want to appear. But I'm delegating that to you and to Ms. Halleck to work that out because I don't know who they want to appear. So, and I know the city has always been cooperative in the past in providing people to explain the rationale for what they've done. And that's what we're talking about here. We're going to get to the 5 subjects. We're going to have Ms. Halleck will examine them as she sees fit. And through an expert, she may say, this is what they should have done. And you will have the opportunity, Mr. Braithwaite, to examine the witnesses after Ms. Halleck to clarify anything you think needs clarification. You'll have an opportunity to come back in rebuttal to address anything you care to address that her expert may have offered.
Mr. Chairman, are we allowed to name an expert? And if so, wouldn't it be customary and appropriate for the appellant to tell us who their expert is, and then we have some time to name an expert in response? Wouldn't that be the way to go?
Well, they are required to tell us. That'll be in their list that comes out 3 weeks in advance. If you have an expert you want to designate after theirs, do it a week later.
Okay, this all going to be in an order? All this spelled out in an order or no?
I'll do my best.
Okay. Okay.
My clerk is off tonight.
Oh,
Just a clarification, you said that I can sit down with a director. Are you referring to Director Nash or director of each department?
Nash, Dr.
Nash, thank you. That's what I thought.
She's
And I
the
will,
supervisor.
I
Well,
will endeavor to do that. Listen, I do hear what everyone is saying, and I will work hard to, I do feel like we've sat through all of this. Believe me, I don't want to make this long. We're all busy, and I thank you for your service because I know it's late. I will do my best, but I think the board needs to hear, and you may sua sponte want to call somebody if you feel that the evidence is not being presented. So I do understand that, and I'm trying to, I'll try and move this along quickly.
good. All right, is there anything else we need to take up in this case before we get on to Mr. Hyatt's encore? No, good.
I just want to address it, it's sort of factual. I know you want us to submit briefs. I'm going to do it. It's going to be brief. I just want to follow up with a point just on that issue on the notice, that in terms of it, I'm going to use this example, that the ad was not placed in the paper because there was a lack of communication from the city as to any of the requirements. Or for example, there's an affidavit that the city provides. I want the board to understand this, that the affidavit that was submitted was prepared by the city that says the 200 residents, owners of the property, and it doesn't say tenants. And that's been provided by the city. I want to be careful. I want the board to be aware when I do this, I'm not going to belabor the facts.
Yeah,
But
so if your
correct.
position is that we shouldn't dismiss for fairness, equitable reasons, you'll put those in your brief.
Fair enough.
Okay, thanks, everybody, in connection with the lofts, and we'll see you. Oh, if there are any other problems that come up that the board needs to address, we do it by motion. And I don't want to see any motions after September 15th, if we can help it. So if you got a problem, let's get it out sooner rather than later. Okay, we can excuse Ms. Halleck and Mr. Henney and Mr. Rogers. And we'll move on with the next agenda item, which is request for an extension in special exception 2018-002. Let's start with Mr. Hyatt. So you understand you have the pandemic emergency extension.
yeah.
And that's 30 days from the end of the emergency, is that right?
Right. So it's still active.
Yeah. So let's come back to the standards for the board granting a second extension. And the question is, what does established mean? And what's the authority for that? Go ahead, Mr. Hyatt.
Thank you. Yeah, this is the church MRG special exception for a standard restaurant right at the top of Main Street in Church Circle.
We're all looking forward to dining there as soon as you can get it open.
I get it. The folks that own this restaurant are called the Mindful Restaurant Group, and they have a number of restaurants in Washington, D.C., and they, good reputation. The special exception order was actually signed by the board on December 31st, 2018. And the code says a special exception must be established within 12 months. Well, from the time the special exception took place, there were, painstaking months of work on that old building because, that old building it goes back to the 1700s and was actually 4 connected buildings, and all the work to shore up the structure had to be done by hand. It was really quite an ordeal, and it dragged on a long time. We asked for a 6-month extension, and that was granted to June 30th, I think. June 30th of this year. And Then, of course, we had COVID, which slowed everything down, going back to March and April. The applicant is moving forward now. They're doing the build out. They finally got or received a permit for the interior build out. And just so you know, Mr. Gutwald's position was that once the permit was received for the build out, that was the establishment of the special exception. You started to build out a restaurant, and that's what he recognized. I know you're thinking, well, what does that have to do with establishment of a special exception? But that's what he told me, and that's what we relied upon, and there's correspondence to that effect. It may not matter because, you're only entitled to 2 6-month extensions. We're riding the emergency right now, so to speak. So what I would respectfully request from you is that you grant a 6-month extension from the end of the emergency period, and that ought to get us to the finish line, because I'm told by my client that by the first of the year or shortly thereafter, they expect to be able to open. So that's the word I got from them. So if that is satisfactory to you, then
are there any judicial decisions on established in this context?
Are there any what decisions?
Judicial decisions.
Judicial, not that I'm aware of. No.
Mr. Hyatt, who's the permit holder's name? Is there a trading as? Is it somebody else's behalf, or is the actual same applicant's name on the permit?
It's on the build out permit. I think it's the same. It's the applicant. I think it's Church MRG LLC.
Right.
But I haven't seen the permit, but that's my understanding anyway.
Well, I mean, I understand Mr. Gutwald's logic there, at least in my opinion, that the entity is doing business. The business is not the business of restaurant business, it's the business of building the restaurant. It's not exactly both feet in the restaurant business established, but it's pretty close.
Right. No, I understand that. And if we get a 6-month extension after the emergency period, it may be a moot point. It may not be necessary to decide whether it's been established or not, and then we move on. But if there's a further delay, then that might be a problem, because we will run out our 2-year opportunity.
Mr. Braithwaite, does the city have an opinion on what established means?
Brief indulgence. The city attorney did have an opinion.
Joelle, I sent it to them. I can say that for most planning applications, if you have a building permit, we consider that vested. However, the code is specifically different for planned developments. And in this case, the code also has that language about establishment that is different than anywhere else in the code. So I asked Attorney Mike Lyles for an opinion, which is what I sent to you about establishment means establishing the use for which they've applied for the special exception for. So
I'm sorry, I didn't see that. Joel, can you summarize that for me?
Give me 1 second. I'm just trying to locate it now in my emails.
And I will say, Bob, that I'm a little fuzzy in my 10 years on the board here, but I think we have used getting the permit and starting work as some kind of threshold. I don't know if it's founded in legal precedent or language within the city code.
that is not in the city code, but it is case law in planning that is typically when a planning approval is vested, since Maryland is a late vesting state. However, there are some situations where our code does say something differently, like plan developments. You have to actually have done substantial site work to be vested. And in this case, the rather vague special exception language about establishing the special exception.
Who has Who has privilege of this decision? Is it by vote, Bob, or is it still your discretion on the second round?
I thought it was mine, but I'd much rather have the support of the board.
I have no issue with the granting of the second. It's a little fuzzy on the basis of, I don't know where we have the right to base it on the end of the emergency. I mean, if the emergency doesn't end till August of 2021, God forbid, does that mean they get till December of August 2021? Just because it's based on some forever?
Yeah, I have the same concern, Chairman.
And forever's a long time.
Forever is a long time, but we are telling all of our applicants right now that that is when their new deadline is 30 days from the end of the state of emergency. And
Okay.
the Office of Laws reviewed that and decided that there's enough of a reason to support that kind of extension. I mean, hopefully the state of emergency is not that long, but there's a lot of things that our department can't do normally right now. And I know that is slowing down some applications. Like, for example, we can't do a lot of our rental inspections right now. So we can't have all of our rental licenses be expired. So we're just doing the best we can given the situation with the state of emergency.
Let me hear from Mr. Braithwaite about what Mr. Lyles had to say.
So Mr. Lyles said that it's better to have a bright line and so as not to confuse everyone. And he says that he would go with operating in accordance with the special exception granted. He believes that best helps put establishment of the special exception in the proper perspective. So he believes that if it's operating in accordance with the special exception granted, then at that point it is established.
So by operating, you mean open the business and serve pizza?
Pizza's what they serve.
Is that right, Mr. Braithwaite?
Well, I don't think it goes to that far factually. I would say operating in accordance. So operating in accordance, it probably says moving towards, so you're taking steps towards establishing the right. So I would think that the establishment of the right is anything that's within that process of establishing. So to the extent that on the way to serving pizza, if there are renovations and other things that must be done, then that is taking steps in accordance with establishing their right.
Isn't getting a final build out permit a step to establishing the right?
I would say that it is. I would say that because if you want to look at establishment and steps to establish, if they would not need a build out permit, but for the grant of the special exception, then it is because of special exception that they're taking action.
All right, here's what I would like to do, and I'd like comments from my colleagues to the extent you like to offer them. If this is my decision, and my recollection is when Derek was the chair, there were some of these where he just acted on them between meetings and told us about it. And I don't remember anything in our rules that makes a hearing necessary on these things. So rather than make this open-ended in response to the concern a couple of you have raised, why don't we do this? Mr. Hyatt, if you come back within that 30-day period and renew your request for an extension, I will grant it.
But that when you mean within 30 days of the end of the state of emergency?
Yeah.
Okay.
I'm asking.
So if he comes on the 29th day after the state of emergency, he gets a 59-day extension.
Yeah. Well, isn't it 6 months? Is it 6 months or 60 days?
I mean, yeah, he gets
6 months.
Up to 6 months, yeah.
6 months and 29 days he can get.
I won't do anything until the state of emergency has been lifted, right?
Okay, so Bob, just to clarify, so we are just continuing the currently submitted extension request for an indefinite period of time.
Why don't we, consider it withdrawn and he'll file it again.
Because you have to file your extension request before the current extension expires.
All right,
And that's why I think it would be
All right.
important that we continue it.
You got me.
I didn't mean to get you.
That's okay.
Bob, I'm completely okay with hearing the city's position that the Office of Law has said 30 days from the end of the state of emergency. If you want to get this off your plate, by all means, grant it. Move on.
All right. Nadine, what about you?
I agree.
All right. Application for an extension for 6 months from the expiration of the emergency extension is granted.
Thank you.
Anything else we can do for you, Mr. Hyatt?
Dismiss that other case.
You used it up on this extension, sorry.
The irony, Mr. Hyatt, didn't escape me that in the last case you were arguing for punctilious application of the finer points of the law, and in this case, your argument is that we really can kind of overlook that.
But here there is in Mr. Hyde's defense, the governor ordered that certain permits that were set to expire and other things that emanate from the state's executive power, as with the land use article, be extended until 30 days after the expiration of the public health emergency. So I believe that there's a distinction with a difference to be had in this case.
Are you angling for a job with Mr. Hyatt? Just kidding, just kidding.
No.
Perish the thought.
All right, everyone. Thank you.
All right. Thank you.
One more thing, Bob, are we doing the special exception approval that Cheryl sent out?
Oh, signing or approving that? Yeah, I thought, has everyone had a chance to look at the special exception for what was it? I forget what
I think it was sent out to everyone, was
The
it?
one where Nadine had the one edit, is that the one?
Yeah,
Yes.
I thought I had it on here, but.
Cheryl sent that out yesterday, I believe.
But I didn't,
Monday.
I didn't send it to everybody.
I didn't get
Okay,
it.
so everybody hasn't seen it yet.
No.
All right.
Just Bob?
So we'll send it around and we'll do it by email.
Yeah.
Okay, just clarifying.
All right.
But you have all the edits, so we could send it around tomorrow, correct?
Yep. I don't have anything more.
What edits were there?
I might be.
I thought Bob said Nadine had an edit.
No, I might be thinking of the meeting minutes.
That was the meeting
That
minute.
was the minutes.
Oh,
Okay.
yeah, right. That was the minute.
Someone to check that footnote.
It was the SPCA.
Yeah.
Oh, yeah,
Yeah,
yeah.
right.
Yeah, I don't
Yeah.
remember any changes on that.
Yeah.
There was that clarification to that one condition, and I had Kevin review it, and Kevin said it was fine.
All right,
That was
so
just a footnote that I wrote.
Right.
we have a motion to approve Cheryl's masterpiece.
They haven't seen it though.
I haven't seen
I
it.
haven't seen it.
Sorry.
We will forward it to all of you tomorrow, and we will expect a response from you by 4:30.
Call me at 4:29,
Find it.
Jackie.
I have a question.
I think that we should schedule a Zoom party for Bob's birthday, and then what we can do is watch videos of Board of Appeals meetings. I really enjoy that instead of going out
New
to
business
dinner.
before the board. Being none.
I have some business.
Yes.
I need to know. I need to know if we're going to put the exhibits in the record on this one, or are we going to just wait until the actual case? You know, that the huge list of stuff we got today.
We better wait till the case. Because we're
Okay.
not on, we closed that case, we closed the record in that case for now.
So you just want to
No,
just carry?
no, I already said all those things were in.
You
So
did
they're
say
in.
they were in there? I missed it then.
Yeah, yeah. I read the list of things that are already in the record in order to try to persuade them to decide the case on the papers.
Okay, so all of those exhibit A through X is in the record for today.
Yes.
Okay, thank you.
And thank you. Who had that motion? Did everyone hear Christian's motion?
Yeah, motion to adjourn.
Second.
Second.
All in favor?
Aye.
Aye.
Thanks,
Thank
Bob.
you.
Good job.
Thank you very
Thank
much.
you.